The next case on our docket is State of Ohio versus Mastrobuono. We are here today with just the appellant in this case, not the appellee. So normally I would be asking you to take your 50 minutes of rebuttal if you know how much time you like, but you have no one to rebut, so you just have your 50 minutes to present your argument. The argument is being recorded, so when you come up, number one, please introduce yourself. Please stay behind the podium so the recording can pick you up, and please speak loud enough so we can hear you on the recording. You should not use the name of any children, minors, or victims during the argument, and if you do, refer to them by initials or by the child or some term such as that. We read your briefs and are ready to proceed whenever you are, counsel.
Thank you, Your Honor. Good morning, and may it please the court. My name is Ron Fry, and I represent the appellant, Mr. John Mastrobuono. There are 4 assignments of error that were contained within the appeal. The first assignment of error is with respect to the purported waiver of Mr. Mastrobuono's right to a trial by jury. And in this case, the trial court erred when it proceeded to a bench trial without a valid waiver in open court. The right to a trial by jury is fundamental under our criminal justice system. The United States Supreme Court has set very high standards of proof for the waiver of constitutional rights. Accordingly, trial courts must not lightly infer a waiver of a constitutional right, specifically a waiver of a jury trial in this case. Both the legislature in Ohio, by way of Ohio Revised Code 2945.05, and the Ohio Supreme Court in the case of State versus Lomax, have set forth the specific requirements that must be satisfied for there to be a valid waiver of the right to a trial by jury. The revised code provides that the waiver must be made in open court after arraignment and after the defendant has had the opportunity to consult with counsel. The Supreme Court of Ohio has repeatedly held strict compliance with the requirements of that statute is necessary, and in the absence of strict compliance, a trial court lacks jurisdiction to try the defendant without a jury. In State versus Lomax, the Supreme Court clarified and explained what the condition for a waiver in open court requires. Specifically, the Supreme Court in Lomax held that there must be some evidence in the record of the proceedings that the defendant acknowledged the waiver to the trial court in the presence of counsel, if any. Absent such evidence, the waiver does not comply with the requirements of the statute and is therefore invalid. Now, the state of Ohio agrees within its brief that that is the state of the law and that the waiver must be acknowledged while in the presence of counsel, if any, that that is the requirement that was set forth by the Supreme Court of Ohio. However, the state does not and cannot cite to any acknowledgement or statement by Mr. Mastrobuono with respect to the purported waiver.
Well, counsel, the defendant was present when they discussed the waiver of the jury trial in court, right?
The defendant was present, and there were statements made by defendant's counsel. However, there was not a single statement made by Mr. Mastrobuono during that proceeding or during any of the proceedings with respect to any right to a trial by jury or purported waiver thereof. The trial court never directly addressed Mr. Mastrobuono, never asked him any questions with respect to the waiver. He never made a single statement during that hearing whatsoever. So there was no acknowledgement by the defendant. And Lomax specifically contemplates a circumstance where there is a defendant who is in the presence of counsel when it says the defendant must acknowledge the waiver in the presence of counsel, if any. Here there's no acknowledgement by the defendant that can be cited to whatsoever. And again, it doesn't require full colloquy, but an acknowledgement is required. The state...
So you're saying that the judge should have at least said to the defendant, is this what you want to do? Is this your signature? Is this, do you understand, what you're doing? Something, that this is his voluntary act.
Correct. I think the key is voluntariness. So the Supreme Court of Ohio specifically gave examples as to what would constitute an acknowledgement in open court. And it really does turn on confirming that the waiver was done voluntarily. And they cite to two cases within their holding, and Gels and Bays. And within Gels, and again, this is within the Lomax holding, within the case of State versus Gels, the Ohio Supreme Court explains that the requirement for an acknowledgement in open court was satisfied where the defendant was addressed directly by the trial court in open court in the presence of counsel as to whether his signature was on the waiver, whether it was done under his own free will, whether anybody forced him to do this. The Supreme Court of Ohio also analyzed the case of State versus Bays within its Lomax holding. And in that case, the trial court engaged in an exchange directly with the defendant, explained the right to a trial by jury, asked questions to which the defendant personally answered on the record in open court with counsel present. Some of these questions included questions as to whether the person was under the influence of any drugs or alcohol at the time. Again, this goes towards voluntariness, and we see this in a number of circumstances within trial courts when forms are handed up to the trial court judge. Here there isn't even the question, is this your signature? The record doesn't indicate that this form was signed in open court either. So the requirement simply was not met, and the waiver, the purported waiver, is invalid. As to whether he had any understanding or whether it was his signature, that's not in the record because there was no acknowledgement on the record.
Well, the state argues that kind of like an implied acquiescence, basically saying, well, you know, the attorney was there, he said he's waiving it, the defendant was there, he didn't say, no, I don't want to waive it. And then so the judge just relied on the attorney's representation and the fact that the defendant did not object to it. What do you think about that?
First, the state doesn't cite to any cases where purported acknowledgments by counsel with no statements from the defendant would satisfy the open court requirement. Secondly, the case law is very clear. The case of State versus Tate, 59 Ohio State 2nd 50, very clearly indicates that silent acquiescence to a bench trial is not sufficient to constitute a waiver of a defendant's right to a jury trial. So silent acquiescence is not enough. That would be opposed to both the legislature's outline within the statute and the holding by the Supreme Court of Ohio within Lomax. It's clear that an acknowledgement must be on the record in open court by the defendant.
In the cases you cite, otherwise was the person there, defendant there, represented by counsel, and like this case, counsel spoke on behalf of the defendant to say, yes, there's a waiver, or were these folks pro se, do you recall?
There is no case that the state can cite to where the defendant is standing with counsel and counsel makes the acknowledgement on behalf of the defendant and that is deemed acceptable or meeting the condition. There is no such case such as that. Now, there are cases that are cited by the state where they cite appellate courts in the 12th district, the 10th district, and the 1st district. Those appellate courts and the cases that they cited actually involve the same situation as this, where a defense attorney made acknowledgments of the waiver with the defendant present. The defendant didn't make any acknowledgement on the record. And the 12th district, 10th district, and the 1st district applied the Lomax holding and held that that was insufficient, that that did not meet the conditions. Now, the state argued that this honorable court should not extend the Lomax ruling in the same way that the 12th district, 10th district, and 1st district did. However, those districts didn't extend the ruling, they simply applied it. They simply applied the ruling, and that's because in those cases, the defendant was in the presence of counsel and did not acknowledge the waiver on the record. So again, there's no indication as to whether this was voluntary or not. And that's one of the primary reasons that the acknowledgement needs to be on the record. There could be any number of reasons as to whether something could be involuntary. And here, although defense counsel was present, that's not what the case law requires, that's not what the statute requires. It requires an acknowledgement by the defendant, not defendant's counsel. And that's specifically contemplated within the holdings, within the case law, and within the statute and the revised code. With respect to the facts of the case itself, the evidence in this case was insufficient to sustain a conviction and was against the manifest weight of the evidence insofar as this case involved a writ of execution where a deputy came to the Mastrobuono residence. Mr. Mastrobuono allowed deputies and Bath police into his house. He didn't have to do that. He consented to them entering the home. They came in, and during the interaction with them, the deputy never provided a copy of the writ of execution to Mr. Mastrobuono. The charge here is defrauding creditors. The writ was never served. There's specific service rules. It could be personally served. If it's not personally served, service would require a certified mailing or regular mail service. Mr. Mastrobuono was never given a copy of this writ. He was never given a copy of the corrected writ. And I say corrected because the writ that was in the possession of the deputy when he went to the Mastrobuono residence was not directed towards Mr. Mastrobuono. It was directed towards Martin Paltrusian Group. And you'll see in the video, which is an exhibit in this case and is within the court record, Mr. Mastrobuono repeatedly asked to view the writ, to take a photo of the writ, to look at the paperwork. He called his wife, he called his attorney. The deputy would not allow him to even view the paperwork. And that's in direct contradiction to what the deputy testified to during trial. But Mr. Mastrobuono was never given the paperwork. Then, after the deputies leave, and after he shows them his garage and offers them to go into the garage, he has 2 other vehicles there. They don't take him up on the offer. They don't take any other chattels or personal property or anything else. They leave without giving him any paperwork, without serving him any paperwork. That very day, he receives an order from the court that denies a motion that was filed in the case. Now that motion has the same case number, it has the same case caption on it, and it denies essentially the execution that was sought. That's what was going through Mr. Mastrobuono's mind at the time. That's the information he had. So he has one document from the court which is denying a motion to execute on his property, and then he consults with 2 attorneys. He doesn't have the paperwork from the sheriff because the sheriff didn't give it to him, wouldn't even let him see it, wouldn't let him photograph it. He consults with 2 attorneys, and then he sells one of his vehicles. Now, in that situation, he had never been served the writ, and when he sold the vehicle, this case, there's no evidence of any debt. This is a defrauding creditors case. No creditor testified. There's no lien that was introduced into evidence. There's no evidence of any debt. There's evidence of writs of execution that contain errors and were never served upon him, but there was never any evidence of any specific debt with any certified judgment or anything of the sort. And again, no creditor testified. There's no indication that anybody had any legal right to any specific vehicle, let alone the blue BMW, and there's no indication that he was legally prohibited from doing what he wanted with his property at that time. And again, to be convicted of defrauding a creditor requires purpose. You have to act with specific purpose. This isn't just knowingly. This is with purpose to defraud. There's no evidence whatsoever of any specific purpose to defraud a creditor in this case. None. The vehicle was sold. When the vehicle was sold, the proceeds of the sale went into his personal bank account. This isn't an asset being sold and money being hidden. There are all sorts of ways that creditors can pursue debt collection actions, including, well, there's a lot of ways to do it, but here, in this case, there was no purpose to defraud a creditor. It wasn't established beyond a reasonable doubt. No purpose whatsoever was in the record. And again, there's no evidence of any lien on this specific vehicle.
Can you tell us what the relationship of the business, the original party that was named on the writ, was there any evidence as to what the relationship was between the defendant and that entity? There's no
relationship whatsoever. I think that's outlined.
Was that in the evidence?
I think that is outlined within the evidence, especially with respect to the arguments made by counsel. And yes, Mr. Mastrobuono actually testified in this case, and he indicated he had no indication or understanding of what Martin Pultrusion Group is. Again, Martin Pultrusion Group, though, no matter what was in the writ, even though it was totally incorrect, it was never given to Mr. Mastrobuono. It was never provided to him. But even if it wasn't supposed to be because it wasn't commanded to go against him. They had to correct the writ. This is not an insignificant error. The state argues that it was a typographical error. This goes to the heart of the writ. There's not a lot of information on the writ. The party it's directed to is one of the primary pieces of information. It's not a misspelling. This is a totally different entity. And with that, we would ask that the conviction be vacated and the matter be remanded and or dismissed in light of the insufficient evidence in this case and the invalid jury waiver. Thank you.
Thank you, counsel, for your presentation. At this point in time, the court will take the matter under advisement and issue a decision in due course.
Thank you.
The court will mail you a copy when the decision is complete and also be released to the high Supreme